the state recently.
Okay, well, why don't we do that? Let's see if they can support that right now, and we will go from there. Just give me 1 second. I don't think so. Ms. Hall, the probation revocations that we have today, are any of them going to be evidentiary hearings? I'm getting a question about whether we need to have the witness stand camera on.
No, Your Honor. None of them are hearings.
Okay, thank you.
You're welcome.
So how do I make them go away, or you'll make it go away? You make it go away? Yes. Oh, done. Look at that. Okay. You can show me later how I could have done that, so you didn't need to. Okay, so Mr. Avery, I think I'm going to have Ms. Snyder have a quick private conversation with you. I'm going to move you and Ms. Snyder to what we call a breakout room. When you're in there, I cannot see you. I cannot hear you. The prosecutor cannot see or hear you. You and Ms. Hall will be able, Ms. Snyder will be able to speak privately, okay? Can you speak up though, just so I can make sure she can hear you?
Yes.
Great, she'll be able to hear you. Let's do that. And Ms. Snyder, you can just let us know when you guys are good to go. Let me see if I can do that now. 6 South and Snyder. Okay, it should work. Thanks. All right, while they are talking, I assume, Ms. Nelson, that Mr. Melnick is back in action. He has all of our afternoon calendar. Have you? You're on mute.
I will reach out to him to confirm, Judge.
Okay, thank you. That's our afternoon calendar. Our next position on the calendar, and we'll flow with the jail as they flow. Ms. Patel, is your case with Ms. Hodge. Is that going to be a final plea discussion today or a different type of discussion?
There will be no plea, so it'll just be a final
Okay,
discussion.
but that's, we're not with I have no discovery. I don't know what the case is about.
No, not that
Okay,
conversation.
all right. So that'll be quick. Ricky Smith is down for a, wow, it's a Y case, probation revocation. Ms. Hall has said no hearings, meaning evidentiary hearings today. Is that something you and Ms. Hall have sorted out?
Yes, we have come to an agreement.
Great. Mr. Bethea, is that a similar situation, Ms. Hall?
Yes, Your Honor.
Okay, great. Ms. Snyder is busy. She's got position 6. And then she is talking with her client in 7. Okay, well, we should be able to work through this pretty well. So, Ms. Nelson, we don't have any inmates who were brought over to Tuesday is our inmate day normally, but we also had Zoom this morning, and that was enough to handle everything we had going on, or am I misremembering?
Golly, Judge, I don't remember.
I think we're Tuesday. I'm fine. I just wanted to make sure.
I don't think that we were having anyone transported. I think everyone was going to. I don't believe I request anybody to be transported, but let me double check for that 1:30.
Okay. I don't know that they're transporting female inmates yet. There had been a lockdown from Union City. Is that still the case? Oh, someone's here. And that's Miss Spikes. Is that the only person here? Okay, Miss Spikes is here for our 1:30. So hopefully.
Okay, now I'm kind of remembering the lights going off. Yes, that's why I scheduled her for the 1st, since they said they were going to be able to transport after the 30th.
Okay. Well, if Mr. Melnick is available, we can start at 1 instead of 1:30 if he wants to take care of it. But we'll see what his schedule and availability.
I will reach out to him.
Okay, thanks.
Is it safe to assume that if the calendar says jail Zoom, that inmates are not brought over?
So good question. I didn't, I started planning for it to go ahead, Ms. Nelson.
I'm sorry, Judge, I didn't mean to interrupt you. The jail Zoom, no, they're not going to be transported unless
Gotcha.
the attorney had been, had requested that they be transported if it was like a motions hearing, something they wanted them at the courthouse. Otherwise, those that are on the jail Zoom are not being transported.
And this is a coincidence that they're overlapping. Our Zoom everyone's Zoom calendar, it's on a 15 half-day rotation. So our next one will be Wednesday afternoon or something.
Right.
Tuesday is our inmate day. And that's why I was asking Ms. Nelson, was anyone brought over? And I just didn't think to reach out to Ms. Nelson midday yesterday to ask. I thought yesterday at around 6, and she was closed for business by then. So I didn't get to figure that out. But normally a calendar for Tuesdays would be folks who are being brought over, because that's our day for folks being brought over. Up, they're back. Hello, Ms. Snyder.
Judge,
Did you and Mr. Avery have enough time to speak?
we did. I explained to him that his offer is essentially the mandatory minimum, and that at this point he does not want that. So we'll be further notice to a trial calendar, and I will continue to talk to the state and see if maybe we can't come up with something else
Okay.
under the new administration.
In the new administration, is there a co-defendant in this case, or Mr. Avery is the solo defendant?
In theory, there's a co-defendant. It was said at his bond hearing that the state intended to re-indict it to add a co-defendant, but that we just got grand juries back, and so I would ask Ms. Call what the plans are about that.
That is correct, Your Honor. There is a co-defendant to this case. We have all of his information. We went out during the pandemic before it was indicted. Hopefully that can get indicted soon. But yes, there is a co-defendant to this case. I didn't write down his name on my calendar, so I don't have it pulled up in front of me, but there is a co-defendant.
His name is Deshaun Garrison.
Right.
Okay, is he in custody, or that would be a grand jury warrant for Mr. Garrison?
I
He
can't
has
remember.
3 open cases, so I would imagine he's in custody. He's just not indicted on this case yet, because this case was a direct indictment for Mr. Avery.
Okay. All right. But it sounds like, Ms. Hall, that the plan is to re-indict, to link Mr. Garrison to Mr. Avery to this set of allegations. And
Yes, Your Honor.
Okay, great. All right. So, Mr. Avery, it sounds like Ms. Snyder did a better job of explaining than I would have. If you were to decide to enter a plea today, the state would offer the mandatory minimum 10 years to serve with no parole. And Ms. Snyder is telling me what's not very surprising, which is that's not something you're interested in right now. Is that true?
Yes, sir.
Okay. Then what we'll do is move your case to a trial calendar. We hope to start up trials early next year. So we should get you back into court pretty soon. If you're re-indicted, to add this other gentleman, Mr. Garrison, that's not going to slow you down at all. We're not going to make you wait. We will get Mr. Garrison in here and figure out what's going on with his part of the case, but that's not going to delay your trial in any way, okay?
Can I ask you one thing?
You can.
I'm just trying to make sure. So, like, what you mean by trial? What you mean by trial?
So the way that your case is going to resolve, there are 3 ways generally a case is resolved once you've been indicted. The state could drop the charges, and I will tell you that that happens very infrequently. The second way, the most common way, is that a defendant and his lawyer, so that'd be Ms. Snyder, negotiate some resolution with the state. And then you all get in front of me and say, you know what, we've worked it out. Mr. Avery's going to plead guilty. We're going to recommend X years. And I hear all that. I accept the plea, and then I give you a sentence. So that's a guilty plea. And I think you know what a guilty plea is. The third way cases get resolved is that you have a trial. So you get in front of a jury, and 12 people from the community hear about what this case is, and the state has the burden to try to convince this jury that you actually robbed someone and took their car at gunpoint, whatever these allegations are. I don't know much about the case because people have not talked to me about the case, but they'd spend a lot of time talking to the jury about the case, and then the jury would decide, did the state prove it or not? And if they proved it, then you're guilty, and then I sentence you. If the state didn't prove it, then it's sort of like that first outcome where the charges get dropped. That's what I meant by trial. Did I answer your question?
So can you explain one more thing to me? What is it? The third one, the guilty plea thing.
So the guilty plea is not what we're doing today, but that's sort of the in-between route. And Ms. Snyder will talk to you more about it. She'll figure out a way to get you on the phone, or she'll come visit. But the guilty plea is when a defendant says, all right, I'm admitting to certain things. I did this or I did that. And then the state would make a recommendation. They recommend whatever. Sometimes it's what we call a negotiated plea, where your lawyer, Ms. Snyder, and then the prosecutor, Ms. Hall, are recommending the same thing, 5 years. And I'm making that number up, but that might be what they recommend. And that's usually pretty persuasive to me because they know more about the case than I do. But sometimes pleas are not negotiated. So you still admit you did these things, whatever it is you're charged with. But Ms. Hall, the prosecutor, says, hey, Mr. Avery should get this many years. And your lawyer says, no. He's a young man. He's a good kid. He's never been in trouble before. He should get this number. And there's some difference. And then I have to decide, well, what are we going to do? He's admitted he did it. Do I agree with Ms. Snyder that the number should be here? Do I agree with Ms. Hall? Should it be here? Should it be down here? As the judge, my job is to figure out what is the appropriate sentence. That's what would happen if you plead. But let me tell you, this is the important part. You can still plead. You could plead tomorrow. You could plead next month. We can get you in here for a trial, and you can say, you know what? I don't want to do that trial thing. I want to enter a plea. So you're not giving anything up today. What Ms. Snyder has told me is that right now, given that the state is offering you 10 years to serve, and you do every day of the 10, you get credit for when you've been in, but a plea to armed robbery, there's no parole. You don't get out early just because you do well while you're in prison. Ms. Snyder has told me that you're not interested today in saying, I will take 10 years. You could change your mind, and next month, you could say, you know what, I will take that 10 years, and that's fine. That might be what we do. So you're not locked into a trial we're just going to move your case to a trial calendar so that we can at least start getting ready for a trial if you end up not being real excited by the state's offer. Okay? Does that make sense?
Yeah.
All right, so we'll see you early in the new year. We may see Mr. Garrison sometime soon as well, and we'll go from there. All right, Ms. Snyder, you'll let me know or Ms. Nelson know if something changes and we ought to get Mr. Avery into court sooner.
Yes, sir.
Okay, all right, thank you, everyone.
All right, drop down to the fifth floor. Now give about 3 minutes.
Okay, what are we hitting next?
Probably either 4 or 6.
Okay, we'll be ready for it. Thank you. So it sounds like they're going down to the 5th floor. Ms. Hall, are you okay doing our 1:30 calendar at 1 o'clock?
Yes, Your Honor. I'm fine
Great.
with that.
Mr. Melnick will be here at 1, and we'll take care of Ms. Spikes. And Ms. Marable, I assume, is going to walk in. She walked in last time, so she'll be here. It has your name on it instead of Mr. Pinion. Are you going to cover it for him, or Mr. Pinion, we'll just need to reach out to him to let him know it's at 1 o'clock?
Probably just reach out to him. I didn't have intentions on covering it. So just
Okay, well, if you just let him know that we're going to do Ms. Marable at 1 instead of 1:30, that would be great.
Okay.
Thanks.
You're welcome.
Judge Miss Marable's on bond, so she might not appear till 1:30, just so that you know.
Okay, but we'll at least take care of Ms. Spikes, and then we can wait for Ms. Marable.
You live now.
All right, who do we have?
We have number 4, Mr. Mosley, or Mr. Smith.
Number 3, number 4. Okay, got it. Okay. Good morning, Mr. Smith.
Mr. Mosley.
Are you able to hear me?
Sir.
Great. Mr. Smith, we've got you here today to talk about a probation revocation situation.
Right.
I'm going to have your lawyer give me an update, and we'll figure out whether what we're going to do today. I had your case up on the screen. Come back to me, screen. There it is. Mr. Smith. So your case is really old. It's from, I think, 1999, maybe 2000.
I ain't been in no trouble since then.
And the allegation is that in September of this year, fast forward 20 years, you committed a new crime, aggravated assault. That's why you're sitting in jail and probation caught up with you. I'm going to ask Ms. Patel, who is working with you on this case, tell me a little bit about the situation, and then we'll go from there, okay?
Okay.
All right. So, Ms. Patel, good morning.
Good morning.
We're testing out the new sound system as well. Tell me what you understand is happening with Mr. Smith today.
Your Honor, I spoke with Ms. Hall and we've agreed to revoke 2 months and to terminate the balance of Mr. Smith's probation.
Okay. Do we have a status of the pending charge, the aggravated assault?
So unfortunately, I explained to Mr. Smith that he'll remain in custody on that charge. Hopefully it'll make it to grand jury floor soon.
Okay.
But we wanted to move forward on the revocation so that at least this could be resolved so that he could handle the case without any restraints.
Makes sense. Officer Crawford, how much time remains on Mr. Smith's case? And good morning to you.
Good morning, Judge. Mr. Smith has 8 years, 11 months, and 16 days remaining.
What was his original sentence?
30 served 7.
30 served 7. Well, that would leave a lot of probation. Got it. Okay. All for a drug case.
Right, possession of cocaine.
Got it. Those were, I guess, the kind of sentences they handed down back then. Okay. Ms. Hall, were you able to hear Ms. Patel?
I was, Your Honor.
Fantastic. Well, that's good news for 2 reasons. The sound system's working, and sounds like you and Ms. Patel have sorted this out.
Yes, Your Honor. Just looking at the face of that case, I felt like that was the best. We felt like that was the best resolution for resolving that case beyond the aggravated assault case.
Okay. Mr. Smith, is your name Ricky Smith or Michael Mosley?
Yeah, Michael Mosley.
What's the name like on your birth certificate?
Michael Mosley, M-O-S.
Okay. All right. So I've been calling you Mr. Smith. That may have been the name that your old case went under, but I guess you're in the jail under the name Michael Mosley?
Yes, sir.
Okay. And my guess then is that your booking number for this ag assault is linked to Michael Mosley. Well, Mr. Mosley, what it sounds like has been worked out is to revoke 2 months of your probation and then close out this old drug case so it's not following you around anymore. You okay with that?
Yes, sir.
Now, you still got these new charges, and the prosecutor's office is going to, I assume, get something in front of a grand jury sometime soon to see what happens. You'll need to work out that case. That case may come to me, but that would only be a coincidence. There are a bunch of judges here who do criminal cases, so chances are you'll be with a different judge and you'll have a different public defender helping you, someone other than Ms. Patel. You understand that?
Yes, sir.
Okay. Well, Mr. Mosley, do you have any questions about anything else?
You said I'm gonna vote 2 of my months. What do you mean by 2 months? Well, I got
do some time with 2 months for violence or something?
Was the agreement credit for time served?
Yes, credit for time served. He's been in since September 26th of 2020.
Okay, 9/26. So, Mr. Smith, Mr. Mosley, what the prosecutor has recommended, and it sounds like your lawyer thinks it's a fair deal, is that it's a 2-month revocation, but those 2 months started running the day you came to jail, which was 2 months ago. So you're pretty much done with your revocation, and that will close out this old drug case where you're known as Ricky Smith. And so what should be the only business you need to take care of is your aggravated assault. Now, I don't know if you have other old cases rattling around out there, but the only one we were aware of was this case from 1999 where you were in front of a judge named Judge Downs, and she sentenced you to whatever sentence you got, 30 to do 7. We're closing that case out now. Does that make sense?
Yes, sir, I like that. I really do like that.
All right. Well, I thought you might. Any other questions, Mr. Mosley?
No, sir. No, sir.
All right. Well, I do find that you violated the terms and conditions of your probation by getting arrested on these new charges. And as a result of that, I will revoke 2 months of your probation. You'll get credit from September 26th, and then we will close out the case. So I'll let Officer Crawford do the magic language, whether it's suspend the balance, close the balance, but there ought to be no more probation for Mr. Mosley, also known as Mr. Smith, in the Y20097 case. All right?
Okay. Yes, sir.
Okay. So, Mr. Mosley, you will next get on Zoom or come to court when something more has happened with your new charges, all right?
Okay. I accept that.
Say that again?
I accept that.
You accept that. Okay, I'm glad you accept it. You have a good day, sir.
Okay.
Did not. If it's negotiated, I usually don't. So this is the 5th floor, so we'll have...
Yeah, we got number 6, Mr. Broughton.
Yep, got it. Snyder popped on. All right. Good morning, Mr. Broughton. How are you doing?
Good morning, sir.
Good. So you are here today for us to talk about whether your case has been sorted out or whether we need to move your case to a trial calendar. Ms. Snyder, good morning again. What's happening with Mr. Broughton's case?
We have previously received a time to serve offer when it was still in front of Judge Reeder. And then we lost Mr. Broughton. He is in on new charges. And so the state and I would like to try to get the new case indicted so we can resolve them together.
Okay. I think that makes sense. I'm just looking up, I have the CP number here. 147. An aggravated battery allegation. Okay.
Yes, sir.
All right. So Mr. Broughton was maybe going to work this case out back in the day with Judge Reeder. Then people lost track of Mr. Broughton. He lost track of us. Now he's got new charges, and the request is hold off on this case, meaning the 17 SC case, to see if we can get the new charges indicted and wrap it all up into one.
So.
Okay. Mr. Broughton, does that make sense to you?
It do, but I've been arrested since April on the aggravated battery. I got arrested April the 5th.
Yeah, and you have no bond on that case. I don't know who handled that, but a judge decided you should not get bond on that. And there's been no grand, let me just finish. There's been no grand jury until a couple weeks ago. We now have grand jurors again. We need grand jurors to indict cases. And because of the pandemic, which you know about real well, there were not grand jurors. The good news is, as of November 13th, we've had grand jurors in here, and I just learned we have our first 4 new cases in our division. So someone will be getting some new cases sometime soon. And we will figure out what's going on there. But what Ms. Snyder was saying, Mr. Broughton, is that hopefully the grand jury will get your case because it's been around for a while. And I'll tell you, they're starting with the oldest cases first and moving up to newer ones. So I suspect yours will get presented to a grand jury pretty darn soon. And then it will come here because you've got this older case. And then you and Ms. Snyder will work with Ms. Hall to see if you can work both those cases out. Does that make sense?
Yes, sir, it do, but I just want to get it handled so I can get out of jail. I can't get out. I just sit here. I'm tired of sitting here. I got to go to Clayton anyway, but.
Well, we need to figure out what that grand jury is doing. So maybe Ms. Snyder will be able to talk with folks in the district attorney's office to figure out where in line your newer case is. I'm hearing you clearly. You've been sitting for a while. Of course, the state hasn't made an offer yet. The state's offer may be that you need to sit a little bit longer. So you shouldn't assume that just because your case gets indicted, the state's going to give you a gold star and say, get out of jail.
I understand.
But we do need to get it indicted. So Ms. Snyder will keep you posted. We're not going to forget about you. We're going to move your case to a trial calendar, but it doesn't sound like we need to try your old case. That one's been worked out. You just can't go anywhere until that new case gets indicted, okay?
All right, what about my old case? What worked out on my old case, Ms. Snyder?
Well, we had the offer that we previously discussed when we sat in my office at the courthouse. But now that the new case has come on, it may change that old offer. So that's why we got to get it indicted so we can see what's going to be the best way to work them both out together.
Okay, what was the offer on? I mean, the old offer. I remember it was so long ago, and the reason, the reason why.
I have to go find my calendar notes. I thought it was in my file, but it's not. I don't remember what it is off the top of my head.
I thought you had mentioned, Ms. Snyder, that it was effectively time served. There may have been probation.
I'm sorry, it was time to serve.
Oh, okay. So that it wasn't a get out and have probation. It was if Mr. Broughton was going to go along with it, it might include some jail time. That being said, he's been doing time, so he's
right.
earning that credit now. Okay. Yeah. Well, why don't you figure out what it was when you're next with the file, and you can reach out to Mr. Broughton so you guys are ready to go on that one. And Mr. Broughton, what we'll do is try to figure out when your new case is going to get in front of the grand jury, okay?
Yes, sir.
All right, we'll see you soon. Take care.
Can you let me know?
Yes, sir.
Thank you.
Hello, Judge.
Adoption paper stuff. Are these our new computers?
They are, and they work real well. Ms. Patel may have the next position, but they're in something called Zoom rooms. And so there's little cameras pop up and everyone can see everyone. And even better, you can hear real well remotely. So all the folks who are not in court were able to hear Ms. Patel real clearly when she was right there.
I'm gonna go to one north. Hold tight for me.
Pardon me, what were you saying?
I'm going to one north next, so you have to hold tight for me a few minutes.
Okay.
Little white box to your left.
This? No, this is like Ethernet outlet. No, the only cameras operating are the ones that, so there's they all are where you see the screens and cameras pop up. So there would be one in your courtroom as well when they set it up. Witness stand, counsel table, podium, and then court report. Well, it's litigation manager is what it's set up for, but mine isn't here. Carl is sitting there, but it's for the litigation manager.
Carl, you're taking real time off the screen in front of you.
Yes, but when we have a litigation manager here, I'll probably bring a laptop so that I'll have a screen to look at. I should be using this screen.
But at least what the budget has is one for, we'll call it your team. You could decide as you talk with amongst your team that your court reporter is going to have it rather than your litigation manager. It's really up to whomever. I think
still has two computers.
Right, and so where is yet another screen going to go? So we'll need to work through that. Someone needs to control it. It won't be controlled by the IT folks if you are needing to turn screens on or off or something like that. But that's why I think the default is to have the litigation manager, because the court reporter will be busy taking things down. But so far it's worked real well with folks who are remote hearing. Of greater interest is how will it work with the jury. But what should help with this one, which is turned off right now, the witness stand, is that the way we plan to have it set up is to have a big monitor in both aisles, so that a juror who's way in the back, sitting where you are, or even a couple rows back, you may not be able to see the witness that well. You can see the witness, but with a screen right back there, you're going to be able to see the witness. That's how you'll view the evidence. So if there's a photo, it can be on the screen for the witness, it's on the screen for the prosecutor, and then it's on the big screen so that the jurors can see it. It'll be on this too, but this is less helpful the further back.
All that's the process of being ordered.
These are sitting in your jury room right now. Oh, the big ones, correct. Yeah, I think they're already here. They're trying to get a big screen in every courtroom so that if this rollout is slow, everyone has the equivalent of one of those clear touches in their courtroom for remote stuff. But the ones that we would use for trials here, which is where trials would be here, or 1C for the first few months, I think they're already here. So I think technologically we're ready to go with jury trials. We just need to start having people move around and see what it's like.
Anything in the process of getting more plexiglass?
People have talked about it. I don't know if David Summerlin is you mean like having it, I thought that looked good. Yeah. I don't know. It might make sense to do that here and next door, because this is where we'll be doing the trials for the foreseeable future. But I don't know the status of that.
All right, well, I'll let you get back to your ring. I have one other question for you. Kate Whitaker and I were changing afternoon, morning times for Zoom.
Mm-hmm.
Who do I need to send that email to?
It would just be the sheriff. I mean, your team would need to know, but there's no one on court admin. It would just be that the sheriff's staff would need to know that now in the morning they need to get your inmates and not Whitaker's. So Terry should know who to work with on the sheriff's department, and if she doesn't, then Marlon Greathouse's team would know.
Thank you. Good to see you.
Good to see you. So I thought we had one other fifth floor. I don't know where Bethea is. I don't recognize that cell number. And then we've got Grogan. Wonder why they've stopped moving people down to the courtrooms there. Work better.
But that is on 1 North.
Oh, that's a 1. Okay, got it. Thank you, Mr. Franklin.
Yes, sir.
Oh, here, yeah.
I think every day they have prelims in the morning, but haven't. It was a while ago that was a true statement. I don't know if it's switched, but usually there is unindicted activity going on.
We need to get into some point with what was asking you to test outplayed witness.
Right.
So very works right. It could be that if it's not working, it's like this pressure is turned off. So just put that on access. Turned out that these microphones just so I could hear how well Judge Newsom Newkirk sounded, because wide open as it did, I wanted to see what it's going to be. And turning it up almost all the way, I was able to hear you fairly well. I talked to Judge Rush this morning about being here today to do the mock trial, and I want to set up wireless mics over there just to see.
Yeah, I think that's great.
But if it works, right, they don't have to have those mics. The other reporters, all they need to do is mount the cable that will take straight to there, and they'll be able to hear it.
Yeah, good. In Richmond County, that's Augusta, they started jury selection yesterday in a 3-defendant murder trial. They used a civic center, so there was lots of room. They were able to socially distance over 60 potential jurors. And the technology they used was headsets. Everyone had on headsets that work a lot like our interpreters' headsets, where one person can broadcast into many, and then you can decide whether you want to let the many broadcast back. So the jurors could hear, but not speak back until when juror 3 was up, they were able to turn on. And so when juror 3 spoke, the lawyers, the court reporter, and the judge could hear juror 3. No one else could. And they said it worked real smoothly. It was a little bit of an outlay to pay for all that, but it enabled them to get around we don't have a room big enough, or we can't try a case where you would need 60, 75 potential jurors. So it's something to think about as it's biting off a lot for your first. Yeah. No, they pay a big price.
Car work with John Wilson from town and other meetings and things.
Yeah.
And it's great because we can just plug straight into the audio system.
Yeah. Is this Mr. Bethea?
Yes, sir.
How you doing today? Mr. Bethea, I'm going to get your lawyer online here, Mr. Franklin. And Ms. Paul is the prosecutor. I'm going to get your warrant up here. Okay. All right. Mr. Franklin, good morning. Tell me where we are in potentially resolving the probation revocation matter for Mr. Bethea.
Yes, sir. Ms. Hall and I have had discussions. I spoke with Mr. Bethea yesterday. We have an agreement to revoke Mr. Bethea for time served and to then continue him on his probation. After speaking with Mr. Bethea yesterday, he is not interested in us trying to resolve the unindicted case at this point in time.
Is the unindicted case keeping him in custody, or is
yes?
Yes. Okay. I'm just looking it up.
It's a criminal damage. He's accused of throwing a rock or a brick or something through the window at 10 Lizzie's. I believe it's the 12th Street location.
Okay. Got it. All right. Officer Crawford, how much time remains on Mr. Bethea's 16 SC case, the one that's before us?
Judge, he has 5 years, 3 months, and 4 days remaining.
Okay. And Mr. Franklin, how long has Mr. Bethea been in custody? When you're saying time served, what are we looking at?
Correct me if I'm wrong, Ms. Hall. I believe we're at like 130 days, thereabout.
Yes, I was at 122 last week or the week before last. So that sounds about right.
Okay. And Mr. Bethea went into custody not because of this warrant, but because of the new charges, and then that triggered the warrant.
That is my understanding, yes, sir.
Okay. Mr. Bethea, have you been following what we've been talking about? Okay. So what, and Ms. Hall, do you agree with what you heard Mr. Franklin say?
Yes, Your Honor.
Okay. So the recommendation to me, Mr. Bethea, is in light of your new arrest for criminal damage to property, I ought to revoke, I'm going to call it 4 months. That's 120 days. You've already done that. So revoke 4 months. You'll get credit for the time that you've been in, and then reinstate the balance. So you'll still be on probation for this older case, the aggravated battery, but that won't be holding you in jail. The only thing you'll need to be dealing with going forward will be your new charges about this breaking the window at Tin Lizzie's. Does that make sense?
Yes, sir.
Is that what you thought was happening today?
I really couldn't understand what you were saying. So you saying, like, okay, they revoked 4 months, credit for time served. I still be on probation for like 5 years and some change or something like that?
That's right. You did understand what I was saying.
Okay.
And then you still got this new charge. I don't know anything about it. It probably will not be my case. In theory, it could be assigned here, but it'll get assigned somewhere. You'll get a lawyer to help you, and you'll need to deal with the new charge. We're not dealing with that today.
Okay.
Mr. Franklin said you didn't want to wait around for that to get charged, and it doesn't sound like the state's going to accuse it. So you're going to just deal with that when the time comes. Is that correct?
Yes, sir.
Okay. Well then, Mr. Bethea, I do find that you violated the terms and conditions of your probation in 16 SC 142024 by getting arrested on new charges. That's not supposed to happen while you're on probation. As a result of that arrest, I will revoke 4 months of your probation. You will get credit from the day you went into custody on your new arrest. And then I will reinstate the balance of your probation.
Okay.
Mr. Franklin, anything else on behalf of Mr. Bethea?
No, sir.
Ms. Hall?
He was booked.
Nothing else from the state.
Ms.
Judge,
Nelson?
he was booked in July 9th, 2020.
Okay, perfect. Thank you. Ms. Crawford, do you need anything else?
No, Judge. I just got it from Ms. Nelson. I was waiting on the credit from date.
All right, she delivered. Thank you, everyone.
Thank you.
All right, going to 2 North now. Be right back.
Okay, we'll follow you.
All right.
He is. Ms. Patel, you have a motion you sent it about a week ago. If I deal with that this morning, I think I don't know that it is e-filed. I mean, I think you would file it. If I deal with that when we're done with this last position, while you're still here and sign it, you can take it wherever it needs to go?
Yes.
Okay, let's do that. Ms. Patel, everything you need is right here.
Thank you, Judge.
Sure.
Here go Mr. Grogan right here.
Thank you. Hello, Mr. Grogan.
How you doing, you know?
How you doing today?
Good.
Good. Mr. Grogan, your case is on the calendar today for what we call final plea. It's a probably fairly brief discussion we're going to have with you and your lawyer, Ms. Patel, who you can see on the screen, and Ms. Hodge, who's the prosecutor, to see if this is a case that is being resolved today by way of a plea, or if instead we should move your case to the trial calendar. Ms. Patel, tell me where we are with Mr. Grogan's case.
Your Honor, I did speak with Ms. Hodge, and I believe that all discovery is complete. She served me with everything that their office has had in the case. I explained to Mr. Grogan that I anticipated that the offer was going to be the mandatory minimum of 25 years, and I believe that that is the state's offer at this point today.
Okay. Ms. Hodge, is that correct? If Mr. Grogan were interested in entering a plea today, it would be a plea to the charges as they are, which would mean that the minimum Mr. Grogan could get would be 25 years to serve, which is what you'd recommend?
Yes, Your Honor, that's correct.
Okay. So, Mr. Grogan, I think you understand that if you were to enter a guilty plea today, which you do not have to do, the state would recommend that you serve 25 years in prison. That's the lowest you could get based on these charges as they stand now. Is that something you're interested in doing today, or should we move your case to a trial calendar?
No, sir.
So it's a oral question. You're not interested in entering a plea today to 25 years. Is that correct?
No, sir.
Okay. You would like me to move your case to a trial calendar?
Yes, sir.
Okay. That doesn't mean you're going to have a trial. That's the next step. It still could be that you and Ms. Patel are able to work something out with Ms. Hodge, but it sounds like the way it stands right now, you would rather have a trial than plead to 25 years. Is that a fair statement?
Yes, sir.
Okay. Ms. Patel, anything else that we need to discuss with Ms. Hodge and Mr. Grogan at this time?
No, Your Honor.
Okay. Ms. Hodge, anything else from the state?
Nothing from the state, Your Honor.
Mr. Grogan, we do have trial calendars now. They are going to start in the new year. So we will move your case in that direction. You've been in jail for a while, I know that. But we will make sure your case is moving along to get on one of those calendars. Ms. Patel will be in touch with you soon, and you guys can talk about next steps, okay?
Okay.
All right, thank you, sir. That should be it. Thank you, Joe. You took care of everything real smoothly. Appreciate it.
No problem.
Ms. Hall, we'll start up at 1 o'clock with Ms. Spikes, who is here. She's in custody. Mr. Melnick will be here at 1. Do you have any success in connecting with Mr. Pinion?
No, he hasn't responded to me yet. I'll give him a call now that we're done with court.
Okay. And Ms. Marable may not show up till 1:30 anyway. The notice she got was for 1:30. But what we'll do at 1 o'clock is sort out whatever's going to happen with Ms. Spikes. Do you have a sense? Is that going to be a plea? Is that going to move to a trial calendar? What is your current understanding?
It'll be a plea. Well, it's supposed to be a plea.
Great. Well, we'll confirm that at 1 and move forward with that. Then we'll handle Ms. Marable. Okay. Anything else from you at this time, Ms. Hall?
Nothing else from me, Your Honor.
All right. Well, thank you, everyone. And we'll get back on. I think it's the same Zoom connection. So I'm not going to hang it up. I'm going to turn my video off. But you can just dial back into this or click back in on this same link, Ms. Hall.
Okay.
Yes, Judge, and wait, Judge, Mr. Pinion said he will be here this afternoon, so he has responded.
Great. Well, we'll see you
All
then.
right.
Thank you, everyone.
All righty. Bye-bye.
Bye. Yeah. So let me see. Yeah, let me see if anyone is still. Ms. Hall left and Mr. Avery's lawyer hung up. So really not appropriate for me to talk with them without prosecutor here and Mr. Avery's attorney. If there's something they want to share, they could reach out to Ms. Nelson and give her a call. I can get you her number and then they can give her a call. So for future reference, they're welcome to come in. If they were the ones who were trying to come in. So it wasn't out. We were already done with Avery? Okay. There you go. You bet. Ms. Nelson is my litigation manager, so she handles all the criminal cases. So if they've got any questions about what's going on, they wanted to, wait, why isn't this happening or that? She may not have answers, but she'll say, here's the phone number for Mr. Avery's lawyer, and that's who can help you out. Okay, thanks. And I'll be back out here a little before 1 o'clock. Great. I will see you then, Mr. Forte.
Have a good one.
You too.
What they've got to go on over to West Side.
Yeah, well, they're almost done, but.
They are going right now?
Yes.
Okay. Need to try to get in there with their through.
Yeah, it should be done.
Thank you.
Mm. Mm. No.
Well, Kelly, I think you want a couple of refills on my prescriptions, please. Last name is Forte, F-O-R-T-E. No, my last name, Connie. Gracie. The furosemide and the Tessigon. Yes, for now. Perfect. Thank you very much. You too. Bye.
There. No sign of Mr. Melvin. Okay, there's Mr. Peterman. Get on. There he is. And there's Miss Hall. Great. I think we've got everyone we need. Good afternoon, everyone. Mr. Melvin, you feeling a little better?
Good afternoon, Judge. I am. Thank you.
Good. We're glad to have you back. This afternoon's calendar is the Melnick calendar. Three positions, two defendants. We've got Ms. Spikes and Ms. Marable to work through. Ms. Spikes is here. She's in custody. So they can bring her out when we're ready to handle her matters. Ms. Marable is on bond. She came into court the day we last had her case on the calendar when you were unavailable. And so I explained to her she'd need to come back. Is the courtroom locked or? Pardon me?
It's open.
Okay, so Ms. Marable has not shown up yet, but
I'm texting her right now.
At 1:30, so she's not late yet. So are you all right if we start with Ms. Spikes?
Absolutely.
Okay, let's bring Ms. Spikes out, please. hope not. Why? Because you got an email saying canceled? I think that was a technical cancellation. I think Ms. Nelson was correcting something on that. We still have a calendar tomorrow, don't we, Ms. Nelson?
Yes, we do. I'm
Okay.
doing Zoom training, setting up training.
No, that's all good. I appreciate again you stepping in for Ms. Hansberry. Mr. Forte had seen the word canceled and thought, hey, we off for tomorrow. I said, no, not so fast.
Judge, I have Miss Maribel on the phone right now. If I can just be excused for a moment to speak with her.
Sure. Hey, how are you? Yep.
Ain't got nobody here with you today?
We do, and he's getting our inmate out.
Okay.
Judge, she is on her way. She's going to be a little bit late.
Okay, we'll see what happens. But again, we will focus on Ms. Spikes first. Good afternoon, Ms. Spikes. How are you?
I'm fine, and you?
I'm doing well. Thank you for being here. Mr. Melnick, can you see him on your screen there?
Yes, sir.
Great. He's here. Ms. Hall, the prosecutor, is here. You can see a little fan spinning above her head there.
Yes, sir.
And I'm going to find out now that you're out here what we're doing. You've got two cases. One is an older case. It's on for a probation revocation, and then the newer case that is on for what we call final plea to see if it's worked out or if instead you want to go to trial. So I'm going to ask Mr. Melnick to tell us what he thinks the plan is, and then we'll find out from the prosecutor, okay?
Yes, sir.
All right, Mr. Melnick, what is it that you think we're doing with Ms. Spikes today?
It's a negotiated plea, Judge.
Okay, and does that involve the revocation as well?
Yes, it does.
Great. Ms. Hall, that's your plan?
Yes, Your Honor.
Okay, great. Then let's go forward. Were you able to hear Ms. Spikes, Mr. Melnick?
Yes.
Great. Our sound system is working well, so you'll be able to stay right there. That way you can see your lawyer. Ms. Spikes, before we get started in 20 SC 174029, I need to make sure that you're okay with the fact that Mr. Melnick is on a screen rather than sitting next to you.
Yes, sir, I'm okay.
Okay. If you need to speak with him in private, we can arrange that. We can step out of the courtroom and I can set it up so that you and he are speaking privately. But hopefully we'll be able to work through things. If you have a question at any point, please let Mr. Melnick or me know. And it may be something we can talk about as a group. But again, if it has to be in private, we'll figure out a way to make that happen.
Okay, yes,
All
sir.
right, great. Okay, Ms. Hall, if you're ready.
Thank you. Ms. Spikes, can you please raise your right hand? Do you swear or affirm the testimony you should give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you. Can you please state your true, correct, and legal name?
Lysandra Denise Spikes.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
Is there any medication that you normally take that you have not been given today?
No, ma'am. I take medicine, but I haven't. I took my mental health meds, but
You said you
take
did.
medication for what, Ms. Spikes?
bipolar schizophrenic, trauma, PTSD disorders, and nightmares.
Okay. And is that medication you've been getting at the jail?
Yes, yes, sir.
Do you get it once a day or once a week? How often?
I get it twice a day.
Twice a day?
Yes, sir.
Morning and night?
Yes, I get my blood pressure, my high blood pressure in the morning. I get my mood stabilizers at night.
So last night, did you get all your mood stabilizers?
Yes, sir.
Did you get your blood pressure medicine this morning?
Yes, sir.
Do any of those medications that you take make it hard for you to understand
No,
what's
sir.
going on?
No.
Okay.
Okay. Ms. Spikes, how old are you and how far have you gone in school?
I have a GED and I'm 38.
Are you able to read, excuse me, are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you've been charged with aggravated battery and aggravated assault?
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to those charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, ma'am.
Have you had enough time to speak with your lawyer, Mr. Melnick, about all the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes, ma'am.
Do you need more time to discuss this case with your attorney?
No, ma'am.
Are you satisfied with his services?
Yes, ma'am.
Counsel, do you waive formal reading of the indictment?
Yes, we do.
Do you waive any and all defects in the indictment, including with respect to the defendant's name?
Yes, we do.
Ms. Spice, have you been arrested on these charges?
Yes.
I ask because the state is unaware of any outstanding warrants that are related to these charges. Do you or your attorney know of any outstanding warrants related to these charges?
These charges, obviously, she does have the probation warrant from the other case. I'm not aware of any other outstanding arrest warrants for her.
No.
Ms. Spice, have your attorney advised you of the minimum and maximum sentence to the charges that you're pleading to?
Yes, ma'am.
The minimum and maximum for aggravated battery and aggravated assault are both 1 to 20 years to serve. Do you understand that this is a negotiated plea of guilty, which means the state will recommend to the court a sentence of 6 years probation with special conditions that you complete an anger management program and that you be a part of the Metro Day reporting program. But the court does not have to accept that recommendation. The court can sentence you to the maximum on these charges, which is the 20 years to serve, and he can run those sentences consecutively or one after another. Do you understand?
Yes, ma'am.
Do you understand this is a guilty plea, which is permanently recorded on your criminal history?
Yes, ma'am.
Do you understand this plea may be used to enhance sentencing on other convictions in this jurisdiction, as well as other jurisdictions, including the federal courts?
Yes, ma'am.
Do you understand if you're currently on probation or parole, your probation or parole may be revoked based on you entering a guilty plea today?
Yes, ma'am.
Do you understand if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, ma'am.
Do you understand you're not allowed to possess or use a firearm while on probation?
Yes, ma'am.
Do you understand if you're not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just as a conviction at trial would? And this is true regardless of any advice by your attorney or anyone else.
Yes, ma'am.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be following a conviction from trial? For example, your guilty plea may affect the right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes, ma'am.
Do you understand that by pleading guilty to a felony, if you use, receive, transport, or possess a firearm, you will be guilty of a felony, which may carry a sentence of 1 to 15 years in prison?
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes, ma'am.
Do you understand if you went to trial, you have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to remain silent and not incriminate yourself?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up the following rights? The right
Yes,
to
ma'am.
I'm gonna give you a no, you're fine, you're fine. I'm gonna read off a list and then you can say if you understand once I'm finished.
Okay.
Do you understand you're giving up the following rights? The right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial.
Yes, ma'am.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No, ma'am.
Is it your decision to waive these rights and enter a guilty plea because you're in fact guilty?
Yes, ma'am.
How do you plead to the charges of aggravated battery, aggravated assault in indictment number 20-SC-174029?
Guilty.
Is this excuse me, I'm sorry. Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
Do you understand that you only have a limited right to appeal this guilty plea conviction?
Yes, ma'am.
Do you understand that you only have 4 years from today for a felony charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, ma'am.
Thank you. Your Honor, had this case proceeded to trial, the state would have proven that on December, excuse me, December the 16th, 2019, in Fulton County, I'll get you that exact address, Your Honor. Officers were called to the location in reference to an argument. The victim in this argument spoke with officers, Ms. Stanson, and she told officers that she got into a dispute with the defendant over $10. At some point, the argument became physical, and the defendant cut the victim across her face with a razor. The defendant was located walking down the street a little bit away from the incident location. She was found with the razor on her person. She did admit to the argument to officers, but did deny using her razor or cutting the victim's face. The defendant was arrested and charged accordingly. I'm going to get you the address for the incident location. And the state is aware, Your Honor, that the defendant has 6 felony convictions, the latest being a 2012 case, which is the 2017 conviction that she's currently on probation for. And she has 1 year, 8 months, and 22 days left. And the incident location was 344 Sawtell Avenue, Southeast Atlanta, Georgia. I'm sorry, I messed that up. My apologies. It is actually 4100 Wendell Drive, Southwest Atlanta, Georgia. And that's as much as I can make out. But that is in Fulton County, Your Honor. And I can give you any of the specific convictions. I know that the defendant does have an aggravated assault, actually 2 aggravated assaults. One was from 2009 and another one was from 2013. The latest conviction was the 2017 case, which was an interference with government property. The conviction date was 2019.
Okay. Did you explore at all, Ms. Hall, having Ms. Spikes participate in the behavioral health treatment court?
Yes, Your Honor. Correct me if I'm wrong, Mr. Melnick. I believe she was not accepted. We did try that route. That's what's taking this negotiation such a long period of time, because we were trying to get her help because we see there's some anger issues and some other issues that may be going on there. But it looks like this came down to our final option without adding on jail time or actual time in jail without getting help.
Okay. Mr. Melnick, did behavioral health treatment court provide a reason for not accepting Ms. Spikes?
She had been in behavioral health court some time ago. And they said because of her prior involvement in behavioral health court, she was ineligible to come back this time.
Okay. All right. Officer Crawford, is the 17 SC case, this interference with government property, is that the only open case Ms. Spikes has?
That's correct. That's her only open case.
Okay. And she's got, it sounds like 5 other older cases that are closed out.
That's correct.
Okay. Thank you.
And I'm sorry, Your Honor, I meant to add, I know we're not dealing with the revocation, but the intention was to I don't know the correct term, but to end the probation, the previous probation, so that she's just on 6 years probation for the current case.
Okay. I learned today, I relearned, I'm sure I've been told before, but it's terminate. It's one of the
Terminate,
3 blocks.
yes.
You can reinstate, you can suspend, and you can terminate. So
Terminate.
when we get there, I'll understand that that's the request.
Okay.
Mr. Malik, you can share what you want after you answer this next question, please. Has Ms. Spikes been in jail since December 16th, or did she get out and then got put back in?
No, she's been in continuous custody since December the 16th, Your Honor.
Okay. Then the 6 years probation is just a figure that the 2 of you came up with?
That's correct.
Okay, all right. Anything else you want to share?
So, Judge, just I had some information about her background. She has had mental health issues ever since she was a child. She experienced significant trauma as a child. I'm not going to get into all the specifics unless you really want me to. She has a stable place to live with her mother, Melissa Williams, in Douglasville. And just so you know, I have confirmed that there is a Metro Day reporting center in Douglasville, and that Ms. Spikes, she and I have talked about it. She has transportation to get to and from the Metro Day reporting center to make sure that she complies with that condition of probation. Your Honor, because of her mental health issues, she's had difficulty getting employment. But her mother has assured me that that Ms. Spikes will have a stable place to live and that she'll be able to keep an eye on her during the course of this probation. We are asking, obviously, that you accept the negotiated plea.
Does Ms. Spikes' mother live at the Soaring Drive address?
That's
Yes,
correct.
sir.
Okay, that's the address we've got on the warrant for her arrest. And it sounds like there was a little trouble tracking Ms. Spikes down last time she was on probation. It sounds like she was sentenced, wasn't all that much time, but she was sentenced in November, and she never reported. In fact, it hit everyone's radar a month and a week later when she got arrested for this situation.
Permission to speak, y'all. They kept saying that they couldn't find anything in the system for me being on probation. So when I had got arrested for these charges, it made me look like I didn't report.
So did you try to report?
Yes, I did, sir. I kept calling and kept calling. They kept indicating to me that they didn't have anything stating that I was on paper.
Were you calling in Fulton or were you calling in Douglas?
I was calling in Douglas and Fulton County because I know I was in Douglas County because Douglas County has to keep an eye on me for Fulton County.
Okay.
So I called Douglas County. They kept saying they haven't received anything on me.
Okay. I got it. Thank you for giving me that update. Ms. Stinson is the person who got hurt in this case. Is that someone you knew? Is that a stranger, a friend, a special friend?
It's a stranger. No, I don't know her.
Had you met her or seen her before this day?
Yeah, we had met before, like a couple of years prior to the incident. But it ain't someone that I just know, no.
Okay. She's just sometimes around when you're like the same neighborhood or?
Yes, sir. And I was gonna ask you, would it be any problem that you could borrow me from that location, Your Honor?
No, it's not a problem at all. In fact, I was asking about Ms. Stinson because I'm going to have as a condition of your probation that you stay away from her.
Yes, sir.
What was the location where this happened?
It was on Wendell Drive.
But what is there?
That drugs and selling your body and.
But it's a house or is it a store? If I went to that address, would I see?
You would see a street, just a big long street. That's it.
No buildings?
No building. They just where everybody hang out at.
Okay. You're going to be living with your mom in Douglasville.
Yes, sir.
Any reason you need to come to Fulton County?
No, sir.
Okay, then we'll make it easy. We'll just say don't come to Fulton County.
Okay.
Right line. Don't come to Fulton County.
Okay.
All right. Unless you've got to come for court or probation.
Yes, sir.
The two reasons. Okay. And you understand that the day reporting center, even the one in Douglas County, you'll need to go to initially every day, not
Yes, sir.
Saturday and Sunday, but if your mom's helping you get there each day, she's going to need to get you there.
Yes, sir. I need that. Yes, sir.
All right. Mr. Melnick, Ms. Hall may have asked this, but do you waive any issues from proceeding on a copy of the indictment? Got a copy here, not the original.
Yes, we waive any defects or any problems with that.
Okay. Ms. Spikes, you would normally sign your indictment showing that you're pleading guilty, but we try not to pass papers around during the pandemic. Do you authorize me to sign the indictment for you?
Yes, sir.
Mr. Melnick, may I sign for you?
Yes, Your Honor.
And Ms. Hall?
Yes, Your Honor.
Ms. Spikes, do you have any questions before I go any further?
So would you suspend the other probation so that I can just be on this probation?
I'm probably going to do that, but I haven't gotten there yet.
Okay.
We're going to take care of this new
Sorry.
case with Ms. Stinson
Okay.
first. That's okay. Any other questions?
No, sir.
Ms. Spikes, I find that there's a factual basis for your plea. I also find that your plea was knowing and voluntary. Knowing means you've understood all the things that Ms. Hall and I and Mr. Melnick were talking about. Is that true?
Yes, sir.
And no other questions other than about your old probation?
No, sir.
Okay. A voluntary plea is one where no one has forced the defendant to enter the plea. You may not be excited about it, but you've decided that it's in your best interest to enter a plea. Is that true?
Yes, sir.
Then I'll accept your plea. I'm sentencing you pursuant to what's called the Probation Options Management Act. And all that means is that while you're on probation, if you have a small or a technical violation, you and probation will work that out. You don't have to come back in front of me.
Okay.
Let's say you miss a day at the day reporting center. They may make you do push-ups or community service or who knows what, but you don't have to come see me because you missed a day.
Okay.
But if it's a big violation, let's say you get kicked out of the day reporting center or you get arrested again, that kind of thing comes back to me. And we'll figure out what the consequences are for that. Mr. Melnick, I believe that count 2 merges into count 1. Typically, aggravated assault merges into aggravated battery, especially if it's the same incident, which it sounds like this is. Do you agree with that?
I do.
Ms. Hall?
I do as well, Your Honor.
Okay. So I'm going to sentence you only to count 1. And for that, I'm going to sentence you to 7 years to serve 1 year. And the balance will be on probation. So it's still 6 years probation.
Okay.
And you have almost done 1 year. And I can tell you that the sheriff is going to let you out because you have, 15 days left, 14 days left. They're not going to send you down the road or anything like that. You'll get released. You'll need to go live with your mom. But that's going to be your sentence. You've got some other cases in the past where it sounds like maybe you weren't on medication, but for whatever reason, you got angry and someone else got hurt. And so I think that a sentence that better reflects what you're working through and the need for you to take this pretty seriously, because if it happens again while you're on probation in this case, if you get in a fight with someone else and someone gets hurt, probably going to revoke a big piece of that probation. Not because we're upset so much as it's just you either because you're not taking your medications or something. It's just not safe for you and other folks. So it's 7 years to serve 1 year with a balance on probation. So that's still 6 years probation. Count 2 merges into count 1. So there's no sentence for count 2.
Okay.
It'll be a special condition of your probation, Ms. Spikes, that you enter into and complete the day reporting center program and any aftercare they have. Whether that's in Douglas County or Fulton County, you and probation can sort out. It is typically where you live. So if you're going to live with your mom in Douglasville, it'll be in Douglas County. It'll also be a special condition of your probation that you have no contact with Ms. Stinson and that you stay out of Fulton County, except for court or if probation requires you to come to the address on Memorial Drive, for example. That's here in Fulton. But other than that, you don't come to Fulton County. Don't come here to shop. Don't come here to find Miss Stinson to say, I'm sorry, or you're not sorry, whatever the deal is. You'll be required to live with your mother. If you're going to move, probation has to approve whatever new address you go to. So you may 2 years from now decide you want to live on your own. And maybe that's okay. But you and probation will need to talk about that.
Okay.
And you're going to need to take an anger management course. You can probably do that through the day reporting center, but you'll learn more about that once you start that program up. But they may well have something like that there.
Okay.
I'm going to waive your probation supervision fees for the first 6 months while you get situated. Officer Crawford, how are we working where Ms. Spikes will be reporting and whether, I don't know that I get to tell Douglas County that Ms. Spikes can go to the day reporting center there. How does that work?
She's going to report to Douglas County, and Douglas County does have a day reporting center. So I'll put everything on the revocation and put it in her notes so they'll know.
Okay. Do you need to get contact information from Ms. Spikes, and does she need to get information from you about where to report?
I'm going to do both. I have her mom's address as 4000 Soaring Drive. Is there an apartment number?
No, that's a house. It's just 4000 Silver Drive.
Okay, and I just need to get your mother's information, and that'll be it.
Yes, ma'am.
So what's your mom's name?
Her name's Melissa Williams.
And do you know a phone number for her?
Yes, sir. Her number is 404-245-1337.
Okay, and I can give you reporting instructions if you have something where you can write it down.
I can write it down,
okay,
and we'll get it to her.
Okay, so she needs to report December the 22nd at 9 a.m. The address is 8473 Durley, that's Durlee Lane. Durlee
Lane.
Suite 400, Douglasville, Georgia, 30134. 30134.
8473 Durley Lane, Suite 400, Douglasville, 30134, December 22nd, 9 a.m. What's a good phone number for Ms. Spikes to call if she's running late or that's a snow day or whatever?
470-303-6860. Ms. Crawford.
All right, hopefully you can read my handwriting. I tried to write legibly. Hopefully I didn't write on a piece of paper you shouldn't have. Nope, that's fine. There we go, thank you. I have one more question, Officer Crawford. Can I request or suggest that Ms. Spikes be supervised by a mental health probation officer?
Yes, I'll put that on the revocation also and in the notes.
Great. Okay. Mr. Melnick, anything else in connection with the first case, the 20 SC case?
No, that's all, Judge.
Ms. Hall? Okay. So it sounds like in light of this guilty plea, that I can take notice of the guilty plea and find that Ms. Spikes has violated the terms and conditions of her probation in 17 SC 151570, which I'm willing to do unless you've got an objection to that, Mr. Melnick.
No, I do not, Your Honor.
Okay. What I'll do in that case is revoke 1 year in light of this new conviction, but Ms. Spikes will get credit from December 16th of last year. And then we will terminate her probation in the 17 SC case. So I'm now answering your question, Ms. Spikes. That case will be closed out.
Okay.
So when you are released from the county jail, meaning Union City, which will be sometime between today and the 15th of December,
okay,
you'll be done with your old case and you'll be on probation for the new case. And on that date that I wrote down there, you need to show up at the probation office in Douglas County.
Yes, sir.
All right. Any questions about any of that?
Yes, sir.
Mr. Melnick, anything else in Ms. Spikes' case?
No, that's all, Your Honor.
Ms. Hall?
Nothing further from the state.
Okay. Ms. Spikes, good luck with everything. Stay safe, all right?
Thank you so much.
Okay.
Thank you, Ms. Marmot and Ms. Hall.
You're welcome.
Thank you, Ms. Spikes.
Your Honor, that concludes my business. May I be excused?
Yes, ma'am. We'll see you tomorrow.
See you tomorrow. Bye, Ms. Nicholson.
Ms. Marable?
That is
Ms. Marable is here.
Yep.
All right.
Great job.
Ms. Marable, if you don't mind sitting where Ms. Spikes was sitting, because that way Mr. Melnick can see you and you can see him and Mr. Pinion as well. Great, there she is. So our other position on this afternoon's calendar is Ms. Marable's. It was on a couple of weeks ago. Ms. Marable showed up in court with like 800 friends and supporters. Mr. Melnick was unable to be here. I explained that to Ms. Marable. She's back again. And it's final plea date. And all that means is I'm going to see if this is a case that is working out with a plea today, or if instead, Ms. Marable, we should move your case as we have Mr. Roberson's onto a trial calendar. Mr. Melnick, has there been any discussion that might lead to a plea today, or should I just hear from Mr. Pinion what the state's current offer is and take it from there?
Probably ought to hear from Mr. Pinion.
Okay. Mr. Pinion, has the state made any offer other than a plea to the charges in the indictment?
That's the only offer at this time, Your Honor. I could foresee, well, I certainly foresee that there would be a different offer shortly. But that is the offer at this time, is to plead to the charges in the indictment.
Okay. Ms. Marable, there will be a change in management in the district attorney's office in 1 month. And it's at that time that Mr. Pinion may be able to discuss other possible outcomes in your case. He's not guaranteeing anything. It could be that new management, of which Mr. Pinion may well be a part, says this case is real serious and things should get even more serious for Ms. Marable. But it could be, and I heard a little bit about your case because of the bond hearing and everything, that the state is willing to offer you a reduction in charges. It doesn't sound like they would make the case go away, but things could change for the better for you between now and the next time we see each other. But for now, on your final plea date, the offer for the state would be you'd need to plead to the indictment, which would be pleading to a life sentence. I'm assuming that at this point, you're not interested in entering a guilty plea and receiving the only sentence I could give you, which is a life sentence. Is that correct?
Right.
Okay. Then what we'll do, Ms. Marable, is move your case to a trial calendar. It will move along lockstep with Mr. Roberson's, because if there's going to be a trial, unless one of the defense attorneys can convince me that you and Mr. Roberson should not be tried together, you'll be tried at the same time. So the jury will just have to hear one time whatever happened the day or night that someone got killed. So you and he'd be tried together. Mr. Melnick will keep you posted. You'll get noticed. I assume, did you get something in the mail telling you to be here today, or was it just because I saw you last time?
Mr. Melnick informed me.
Okay. I want to make sure we've got a good address for you in the system, because Mr. Melnick was doing his job, but someday he might not be able to find you, and you will be getting something in the mail. And that's the official notice to be here, as opposed to Mr. Melnick saying it would be a good idea to show up. And he's usually right about that. Here you are. Hardy Street?
Yes.
28D Delta?
Yes.
Not 46D?
No.
Delta. Okay. I think that's what we've got. Yeah, 28D Delta. Okay. Then you will get stuff. We may not have sent something out to you today because it was a quick reset from last time. But going forward, the next thing you get will probably be a trial notice saying you got to come on down for your trial. It doesn't mean you have to have a trial again. Mr. Melnick and you may be able to work something out with the state. But if not, next time we get you here, it'll be to figure out how to do the trial of your case. And we hope to start trials up early in the new year. Mr. Pinion, anything else we need to cover in Ms. Marable's case?
I don't believe so, Your Honor.
All right. Well, we will move it to a trial calendar. Mr. Melnick, anything else?
Well, just so you know, just kind of touch on something you had mentioned, Judge. There is a very clear Bruton issue in this case. The Bruton issue really belongs to Mr. Roberson. Ms. Marable gave a statement after she was arrested. And I had hoped to discuss that with Ms. Snyder. I reached out to her, but I haven't heard back from her yet. I don't know if she's going to be on the case moving forward, but I did sort of just want to put that out there so that everybody's aware of it as far as proceeding and moving forward.
Okay.
So just so everybody, just to kind of put that out there, obviously the state could elect not to use the statement and then there wouldn't be a Bruton issue, but assuming the state is going to use the statement, that's something we'll have to deal with at some point.
Sure, and that may be one of the reasons why Mr. Pinion was thinking there could be a offer in the future other than plead to the indictment. Ms. Marable, your lawyer was not speaking in code. There's a famous U.S. Supreme Court case called Bruton that says the prosecution can't use the statement of one defendant against another if that statement implicates the other defendant, if they're going to trial together, because no one can make you testify. And so I'm just making this up, but let's say you told the police, Roberson did it. The state wants to use that. That's helpful because here's someone saying that. But Mr. Roberson can't make you take the stand. So he couldn't cross-examine you, which would mean the state can't use that statement if you guys are going to trial together. That's what Mr. Melnick is alluding to. There are ways to work around it. One of the things, as Mr. Melnick mentioned, is the state could say, well, we're going to not use the statement. But usually prosecutors want to try to use something like that. So it sounds like there are conversations to come with you and Mr. Melnick and the DA's office. You just need to make sure you remain available to Mr. Melnick and abide by all the conditions in your bond.
Okay.
Okay. All right. Thank you, everyone. Appreciate it.
Thank you.
I think that's it. Ms. Rolak, anything from your end, or are you all set?
I am good, Judge. Thank you.
All right. Well, we'll see everyone tomorrow. Appreciate it.